Hello everyone. Today I will be talking about the recent judgment given by the Delhi High Court in the case of Ravneet Kaur versus Prithpal Singh Dingra. In this case, it was held by the Delhi High Court that right of residence under Section 19 of the Domestic Violence Act is not indefeasible in shared household when daughter-in-law pitted against the aged in-law. So when we are talking about domestic violence, we should first understand what do we understand by domestic violence. So domestic violence is violence that occurs in a domestic setting, such as in a marriage. So the victims of domestic violence are overwhelmingly women, and examples include dowry, harassment, sexual abuse, etc. So in India, there have been laws which have been made to protect women against this domestic violence act. So similarly, there is an act that is Protection of Women from Domestic Violence Act 2005. Now, this act protects the right of all women in a domestic relationship to live free from any form of domestic violence, and it has been entered into force in 2006. This particular act defines domestic violence for the first time in Indian law. And the definition of this domestic violence is broad and includes all forms of violence which can be physical, sexual, verbal, emotional, and economic abuse. So it is a civil law which is primarily meant for protection orders rather than criminal enforcement. Now, when we are talking about this case, in this case, the issue that was raised before the court, the issue that the court was deciding was in relation to Section 19. So, under Section 19 of the Domestic Violence Act 2005, a magistrate may pass a residence order if the magistrate is satisfied that the wife has suffered domestic violence. And as women generally do not own property, the right of residence protects their eviction. So there are a number of judgments in relation which are of similar nature. Okay, so like if we talk about the case of Rama Rajesh Tiwari versus Rajesh Dinanath Tiwari. In this case, the Bombay High Court made it clear that women have the right to reside in their matrimonial house, and the Domestic Violence Act has been enacted to secure the right of a woman to reside in a matrimonial house or shared house. Similarly, in the case of R. Batra versus Tarun Batra, in this case, the Supreme Court held that a wife has the right to claim the right to residence for a shared household. However, the shared household has been interpreted as the house in which the husband is a member. Then there is a case of Satish Chandra versus Sneha Ahuja. In this case, Supreme Court held that even if the husband does not hold the ownership of the house, then also it will be called as shared household under the definition of Domestic Violence Act, and the court struck down the judgment of S.R. Batra versus Taruna Batra. Similarly, in this case, in our present case, the Delhi High Court ordered that the court that the right of residence under the Domestic Violence Act is not indefeasible right of residence in a shared household, especially when the daughter-in-law is pitted against the aged in-laws who wish to evict him. So the court held that senior citizens are entitled to live peacefully and not to be haunted by the matrimonial discord between their son and daughter-in-law. And the court made it clear that until alternative accommodation was provided to the wife by her husband, the wife won't be evicted from her house, from that house, as per the provision that has been provided under the Domestic Violence Act 2005. So this was all about this recent case of Ravneet Kaur versus Prithpal Singh Dingra. I hope this case was helpful to all of you. Please do like, share, and subscribe to my channel. And in case you have any query in relation to legal matters or law exams, you can reach out to me on my email ID or on my Instagram ID. Link for the same is provided in the description below. Thank you very much.